Hello and welcome everyone to our November Grand Rounds. Thank you for joining us today. This promises to be a very interesting and I think important conversation. My name is Deborah DeBruin. I direct the Center for Bioethics here at the University of Minnesota. And before we begin today's presentation, I'd like to take a moment to acknowledge the tragic events at the University of Virginia earlier this week, where a number of students were shot as they returned to campus from a class field trip. The suspect in this case is also a UVA student. That beautiful and vibrant campus, now in shock and grieving, is the community that one of our speakers today, Dr. Marshall, calls home. Of course, this is not the only site of gun violence in our country in recent days, or even the only campus affected by homicide this week. And simply acknowledging these issues is really not enough. But it is important to recognize the impact of violence on individuals and families and communities. So I wanted to take a moment to be mindful, even as we acknowledge that much more must be done to address the problem. Without further ado then, let's talk about logistics for today. So if you have questions for the speakers, please use the Q&A function that you find at the bottom of your screen to type in your questions. We'll be having a discussion about your questions at the end of both speakers' presentations, so when we've completed both presentations. But you can input those questions at any time, so you don't need to wait until the end to type them in. If you have technical difficulties, you can also use the Q&A function to let center staff know about them, and they will help you manage those privately that way. This event is being recorded, and the recording of the event will be available on the center's website a few days after the event has finished. I would like to ask all of you to consider submitting an evaluation for today's event. We take your input very seriously. There are 3 ways to access that evaluation. It'll pop up in your web browser after the event. It's linked in the presentation details document, which will be available in the chat today. There'll be a lot of information for you in that presentation details document. You'll also receive an email after the event with a link to complete it if that's the most convenient way for you to do it. Next slide, please. For University of Minnesota students with active status in health professions programs, this event has been approved for interprofessional education credit. And if those students would like to pursue IPE credit, we ask that they complete the reflection form, which is linked in the presentation details document in the chat. For professionals who are seeking certificates of attendance for continuing ed units, please complete the form linked in the presentation details document, which again is in the chat. It can take a few days for those certificates to be issued. And I do have to note that based on the requirements of the accrediting agencies, you need to attend a minimum of 75% of today's talk to receive a certificate. Finally, biomedical engineering students, please email your program. The email address is on the slide and also in the presentation details document. If you email your program indicating your attendance, you can work with your program to secure ethics credit for your attendance at today's event. Next slide, please. I want to take a moment to thank our co-sponsors. Those of you who attend our Ethics Grand Round events regularly know that we work in partnership with other units across the university for every event that we host. And today's event is no exception to that rule. So I'd like to extend my gratitude to the law school, the Center for Women's Health Research, the Center for Anti-Racism Research for Health Equity, the medical school, the School of Nursing, the program in Gender, Women, and Sexuality Studies, the School of Public Health, and the Center on Women, Gender, and Public Policy. We really appreciate their partnership on this event. Next slide, please. At this point, I would like to introduce our speakers to you. I'm just going to do short introductions so that so as to allow as much time as possible for discussion of the issues before us today. You can find fuller bios for each of the speakers in the presentation details document and on the center's website. So I'll begin with Dr. Mary Faith Marshall, who is the Emily Davey and Joseph S. Kornfeld Professor of Biomedical Ethics at the University of Virginia. She directs UVA's Center for Health, Humanities, and Ethics and its program in biomedical ethics. She also co-founded and co-directs UVA's program on studies in reproductive ethics and justice. Lynn Paltrow is the executive director of the organization now known as Pregnancy Justice, formerly known as National Advocates for Pregnant Women, which she founded in 2001. Pregnancy Justice works to ensure that no one loses their rights because of pregnancy or because of their capacity for pregnancy. We'll hear a lot more about the sorts of issues that the organization works on during today's session. At this point, Dr. Marshall, I'll turn it over to you.
Can you see my slides, folks?
Not yet.
Not yet, Dr.
Okay,
Marshall.
let me try again. Thank you.
There we go.
There we go. All right. Well, I want to thank Dr. DeBruin and the Center for Bioethics and all of the co-sponsors for inviting Lynn and me to make this presentation. It's an honor and a privilege to be here with all of you today. So thank you. Thank you. Our talk today has grown out actually of decades of work that Lynn has been doing and that I've been doing on for reproductive ethics, especially coercive interventions in pregnancy and policy approaches to perinatal substance use disorder. And Lynn's work as an activist and an attorney who represents pregnant women in a number of venues and does important research with her organization, and has been involved in some of the most important cases involving incursions against pregnant persons in this country. Our talk today grew out of a paper that was published in August in the American Journal of Bioethics. And so this is our kind of disclosure that we have nothing to disclose, no funding associated with the work featured in the article. We began work on this paper almost a year ago. We were working hard in December of 21. Also want to acknowledge, and we say this in our paper, which I know was made available to you all. There's, I think, a link to it in the announcement of the Grand Rounds. But this is a photograph of a transgender couple who are pregnant, and we just want to, sort of acknowledge that not all people are, with the capacity for pregnancy identify as women. And so in our paper, we use the terms women and pregnant women to be inclusive of all. This is actually the a card, the cover of a card that I bought when I was in London some years ago, and it- it- the heading reads, "Shall we join the men?" And it reminds me to say, right, or to point out the fact that it is the case of being pregnant itself, right, that invites incursions against pregnant persons, and incursions involving lack of privacy, liberty, uh, bodily integrity in ways that would never happen in men or other people who are not pregnant. And that's really an important point, and one that we're going to focus on also in our, as we move along today. Okay, and my slides are not, sorry folks, for some reason my slides are not moving. There we go. Want to start with a little history. I'm going to give some history, and I think Lynn is going to talk about history because it's important how we got here, and a bit about where we are today, and that will be a lead into Lynn's talk. This is a photograph of Horatio Storer, and I think the racist and the eugenic origins of sort of at least some of, and I think a fair portion of those who are anti-abortion have their roots in either eugenic origins or racist origins. And so this is where it formally began in the United States with Dr. Storer, who mounted in 1857 the Physicians' Crusade against abortion. And he partnered with the newly born American Medical Association. In 1860, he authored a ghostwritten letter that the AMA sent to all of the governors in the United States, and making the point that for the first time that the child, his language, is alive at the moment of conception rather than the current norm, which was at quickening. And he was also the author of an 1865 American Medical Association essay, "Upon White Women's Loins Depends the Future of the Nation." And he founded the AMA Committee on Criminal Abortion, which endorsed the sterilization of undesirables. And so moving to today. These are some quotes from an article that came out in 2020, was published in The Nation. So 2 quotes: "Lots of our people join the anti-abortion movement. It's part of our holy war for the pure Aryan race." Representative Tim Bishop of the Aryan Nations. And the second: "More than 10 million white babies have been murdered through Jewish engineered legalized abortion since 1973 here in America, and more than 1 million per year are being slaughtered this way. Abortion makes money for Jews." The central thesis of our paper, and what we're going to talk about today, is that the Dobbs decision, moving beyond Roe, is not just about pregnant persons or those who are seeking to end their pregnancies. There will be widespread, and there are widespread repercussions that can involve nearly all women, those who become pregnant, those who have healthy newborns, persons with pregnancy complications or adverse pregnancy outcomes, and their families and those who care for them. Some background conditions, the lay of the land. So the majority of women of reproductive capacity, 58%, live in states that are hostile or extremely hostile to abortion rights. In 2021 alone, legislators signed 108 abortion restrictions into law. And as we argued in our paper, this is going to bring whole-scale, large suffering in a number of ways, including short and long-term economic insecurity that includes food and housing insecurity, loss of employment and bankruptcy. We know that historically, those with the fewest resources seek abortion care at the highest rates. Half of abortions in the United States are sought by those who live below the federal poverty level. And 3/4 of people seeking abortion care report the inability to afford basic living expenses. Structural racism is endemic, right, in reproductive health. And we know that lack of access to abortion services, maternal health services, have disproportionate impacts on persons of color. We know that it may perpetuate physical violence for men who are involved in the pregnancies. It will, back to the thesis statement that I made a couple of slides ago, it will cause suffering for those whose pregnancies are initially desired, but become undesired for reasons such as when families learn that the baby they hope to have has severe anomalies, including anomalies that are incompatible with life. And we also know that Roe made treatment available for pregnant persons who need swift and life-saving treatment in cases of pregnancy complications such as ectopic pregnancies, hemorrhage in the setting of miscarriage, and severe uterine infection or sepsis in the setting of pre-viability rupture of the membranes. More about that later. A paper that has just come out on November 15th, published in JAMA. These are based on CDC data. More than 4 in 5 US pregnancy-related deaths are preventable. Almost 1 in 4 of these deaths were related to mental health conditions, including suicide or overdose related to a substance use disorder. So I'm going to talk about mental health issues and show you some cases about that in a few minutes. So in their study of 1,018 pregnancy-related deaths, there were 82 suicides and 29 homicides. And almost half of the maternal deaths were among white persons, but 31% occurred among Black persons, who represent, as we know, 14% of the US population. Talk about the scope of criminalization pre-Dobbs. We know that it has more than tripled across the country in recent years to include more than 1,300 cases from 2006 to 2020. We know that because of the work that Lynn Paltrow and her colleague Jennifer Flavin published in 2013, an important paper. Lynn and her colleagues have updated that information. There are additional 413 cases. There may be more. And this represents then the total of 1,700 cases of arrests, prosecutions, detentions, or forced medical interventions like cesarean surgeries carried out against pregnant people. What kind of cases are these? What do they involve? So they involve women who have experienced stillbirths or miscarriages. So persons who had planned on taking their pregnancies, these were desired pregnancies, voluntary pregnancies, that the pregnant person had planned on, taking to all the way to live birth and a happy family, one hopes. Those who had abortions, have given birth to healthy babies, or who have substance use disorder. Actions taken against women who have fallen down the stairs, self-managed abortion, attempted an abortion, have delayed a cesarean section, eaten a poppy seed bagel and subsequently tested positive in a drug test, or haven't gotten to the hospital quickly enough on the day of delivery. Talk just a moment about carceral pregnancy. 1 in 25 women in state prisons and 1 in 33 in federal prisons are pregnant when they're admitted to prison. These are data from the Sentencing Project. Once they have their babies, there are few institutions that offer services such as nursing programs. And unfortunately, not all of these women maintain custody of their children after birth, even those who have been charged with nonviolent crimes. So there are an estimated 58,000 admissions of pregnant women into jail and prisons every year. And thousands give birth or have other outcomes while they're still incarcerated. And the data for youth are similar to those among adults. In some state prisons, miscarriage, premature birth, and C-section rates were higher than national rates. Only a third of prisons and jails had any written policy about breastfeeding or lactation. And even where those policies did exist or do exist, relatively few women are actually breastfeeding or pumping. An estimated 8,000 admissions of pregnant women with opioid use disorder into prisons and jails each year. But long-term treatment using medication is the exception, not the rule. That's part of a paradox I'm going to talk about in a moment using some real cases. And a related study finds paternal incarceration, interestingly, is also linked to adverse birth outcomes like low birth weight, which are widely known to impact long-term health. And this is the PIPS, the Pregnancy in Prison Statistics. This organization, I'm not going to read this to you or go over it, but that's the source if anybody is interested in finding those data. This is a photograph of the former Robert E. Lee statue in Richmond, Virginia, where I live, from where I am speaking. The color of justice, racial and ethnic disparity in state prisons, the Sentencing Project. We know that Black persons are incarcerated in state prisons at nearly 5 times the rate of white Americans. Nationally, 1 in 81 Black adults in the U.S. is serving time in a state prison. In 12 states, more than half the prison population is Black, and that includes Virginia, the state that I live in. 7 states maintain a Black to white disparity larger than 9-to-1, and that includes Minnesota. Latinx individuals are incarcerated in state prisons at a rate that is 1.3 times the incarceration rate of whites. I want to talk about substance use disorder while pregnant. So maybe harking back to the theme of substance use disorder, other mental illnesses, and again, sort of the often punitive and retributive policies that are used against persons who have those disorders. I first met Lynn when I was at the Medical University of South Carolina. I had only been there about 3 weeks when I learned about a tripartite venture between the Medical University of South Carolina's obstetrics department, the solicitor of the Ninth Circuit Court, Charles Condon, and the Charleston City Police. And they were testing pregnant women who came to their clinic, not private patients, without their knowledge. They were doing urine screens, drug screens on them without their knowledge. I want to mention a particular case, Angelia Kennedy in South Carolina. She suffered a stillbirth, was charged with homicide by child abuse. And the detective who was interviewing her asked her, "Did you do everything in your power to ensure that you would have a healthy baby?" Right? And the obvious implication being that if you didn't do everything in your power, that somehow is a criminal offense, because she received a 5-year sentence. I know that you can't read this slide. This is the informed consent document that patients like me and those in the obstetric clinic at UVA sign when admitted to the hospital or when going to one of the clinics. And it's this paragraph right here that I want to call your attention to. It's 5 sentences long, and it ostensibly provided informed consent to having one's urine screened without one's knowledge in the obstetric clinic if you met certain criteria or were profiled a certain way. I consent to testing for infectious diseases, and I further consent to the testing of drugs if deemed advisable by my physician. I'm going to show you just 2 minutes of a BBC video that was made in South Carolina, and it shows one of the 39 women who was arrested, actually being arrested. There is not much, there's music on the video, but not much talking, except at the beginning, you'll meet Charles Condon, the solicitor of the Ninth Circuit Court.
The controversy here, or the tension exists between the private interests that you talk about, but they really ignore the rights of the unborn. And that's really what this program focuses on. You have a right to have a baby. You have a right not to have a baby, but you do not have a right to have a cocaine affected baby. And so once the mother has her right decides to have a child, she does not have a right, certainly when the fetus becomes viable, to take a drug that is per se illegal in South Carolina. And so it is at that point when the mother chooses to take the drug, that is a crime to take it after all, that we intervene.
Dr. Marshall, we could hear that quietly, but we couldn't see it.
Oh, should we stop? Should I? Okay, hold on. Sorry. Oh, dang. Screen sharing is paused. Resume share. All right, let me try again. I apologize, folks. And if it doesn't work, I'll just, can you see this now? No, it's paused. New share. There we go. Let's try this. How's that? Can you see that?
Yes.
Okay.
And have gone to ground. There have been 20 such arrests in the last 18 months.
of America.
All right. Can you see my screen now? My slides?
Yes, but you're not in slideshow mode. That is to say, we see all your slides.
Yeah. There we go. Whoops, moving this down to the bottom. Okay. There we go. So we know that actually the majority of states have punitive rather than supportive legislative environments regarding substance abuse in pregnancy, and I would add the word retributive to that. In Alabama, for example, there are at least 40 cases of women who are charged under a chemical endangerment statute. And this is one example of the creative use of existing legislation that kind of shoehorns using legislation that wasn't intended for a certain purpose in order to bring causes of action against pregnant persons who have substance use disorder. And so a couple of those cases. These are two young women in Alabama who were arrested in May of this year. Shane Sebastian on the left, Kay Morris, Ashley Kay Morris on the right. Miss Sebastian had opiate use disorder and was actually using buprenorphine, which is a drug that's used in treatment programs for those who have opiate use disorder. And Ms. Morris admitted using marijuana during her pregnancy. And they're both being held in jail on a $10,000 cash bond for chemical endangerment charge. Okay, and I just want to show you this briefly. This paper came out on the 9th of this month, and a study that looked at racial and ethnic disparities in buprenorphine treatment duration in the US. And once again, racial and ethnic disparities in treatment duration that is increasing. And the authors posit that it reflects disproportionate structural barriers in treatment retention for opiate use disorder. And that drug overdose mortality has also increased, especially, again, among racial and ethnic minority populations. Want to show you another Alabama case. This one, young woman named Brooke Shoemaker is among the 20 women in Alabama who has suffered a miscarriage or a stillbirth. They face harsh criminal or harsh consequences from criminal charges. And Ms. Shoemaker, who had a stillbirth and had methamphetamine in her system, was sentenced to 18 years in prison. And she's a college graduate, a mother of 4, and says she now regrets not taking the stand at her trial. Not that the fact that she is a college graduate or a mother of 4 is necessarily pertinent, except like with other pregnant women who fall under the purview, excuse me, of law enforcement, the majority of them have other children. So it's not just the newborn who's not able to bond with its mother. Other children are absorbed into, if they're lucky, the family system, and if not, into foster care. Another young woman, this is May of 22, admitted she had smoked marijuana on the day she determined she was pregnant. This again is Alabama. She was incarcerated for 3 months, even though she had a high-risk pregnancy. Was told the state of Alabama did not accept her $10,000 cash bail. She was actually able to come up with it. And 2 substance use disorder specialists determined that she didn't qualify for state addiction services. So the paradox that I referred to earlier, you must do this, however, it doesn't exist. That's what happened in Charleston, South Carolina, too. And then again, an infamous law and program that was passed in Tennessee, the fetal assault law, and existed between 2014 and 2016, focused on substance use during pregnancy, criminalizing it, causing bodily injury to eggs, embryos, or fetuses. 124 women had charges brought against them. All were low income. Most were rural white women who lived in East Tennessee. And the next greatest number of cases were majority African American women who lived in Memphis and West Tennessee. And again, the paradox, several of them had tried to enroll in treatment programs. And the same thing happened in South Carolina. If you have substance use disorder while pregnant, that's by definition a high-risk pregnancy, and many programs, treatment programs, substance use treatment programs do not accept persons who have high-risk pregnancies. Okay, and so this was the upshot of that 2-year experiment. Same thing happened in Tennessee that happened in South Carolina. So we knew better, and they did it anyway. And it was endorsed by the Tennessee Medical Association, I might add. And so women were driven away from prenatal care because they were afraid of being prosecuted. Okay, and here, I was stunned when I read this. So talking about the war on drugs, this is part of the war on drugs. That has led to vast criminalization of people in the United States. This is a quote from John Ehrlichman, who is Richard Nixon's White House counsel, in an interview that was done in 2016. You want to know what this was really all about? The Nixon campaign in 1968, the Nixon White House after that had two enemies, the anti-war left and Black people. We knew we couldn't make it illegal to be either against the war or Black, but by getting the public to associate the hippies with marijuana and Blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did. And this is very recent, just this month, Jose Irizarry, a DEA agent, was arrested, and he has, in his testimony, said you can't win an unwinnable war. The DEA knows this, and agents know this. And he said the drug war is a game. It was a very fun game that we were playing. And then here's a selfie by him, part of the game, right? 3-continent joyride known as Team America, that shows cities for money laundering pickups, and going to Real Madrid soccer or Rafael Nadal tennis matches. Okay, here are data that are also recent OBG, the Journal of Obstetrics and Gynecology this year, CDC data, pregnant women, deaths of pregnant women by homicide or suicide, and homicide deaths there were 3,203, suicide death 7,000. So suicide happens a lot. These are just some general data about deaths of pregnant women. 68% of pregnant women killed by their partners were murdered with a firearm. 37%, almost 38% Black, and 13.4% Hispanic. Rates of homicide associated with state level rates of gun ownership and firearms legislation. Of 7,208 deaths by suicide, 6.9% Black, 8% Hispanic, 85% white. And so this is especially troubling. Having a mental health problem and any substance use significantly more often associated with suicide deaths than homicide deaths. And intimate partner violence prevalent in both groups. I'm going to talk about two cases, and I'm going to move on quickly here. This is Bebe Shui. Lynn was involved in this case. A woman who was pregnant by her boyfriend, who was a married man. He broke up with her. She attempted suicide by drinking rat poison. She was hospitalized. She lost her fetus. She was jailed for 435 days and charged with murder. And again, creative use of feticide statutes. This is a case you probably haven't heard about. This is a young woman from North Carolina with a sad sort of social and biological phenomena that she lived with. She was hospitalized 13 times starting at age 10, under DSS custody, but allowed to live at home. Was in special education, failed 3 grades, prior suicide attempt, major depression. You can see the diagnoses here. In 2005, she attempted an overdose. At that point, she was living in a tent and homeless. In August of 2008, she was, life had improved. She was living in South Carolina in these apartments. She was pregnant, had an argument with her boyfriend, kind of same thing. And they lived on the 1, 2, 3, 5th floor. And she threw herself out the window and landed on this canopy, which is a hard, not a soft canopy. So August, she attempts the suicide. She is hospitalized for 6 months, much of it in an intensive care unit. The day she comes out, she's arrested for homicide by child abuse. And then the same story as Ms. Shui. Plea bargains for involuntary manslaughter, 8 months in jail, 18 months probation. And 2 more cases. This is Tallahassee Memorial Hospital, a case that was written up by a bioethicist as rogue obstetricians at play. In 2009, Ms. Burton, whose obstetrician wanted her to come into the hospital for bed rest, and Ms. Burton, who is a mother of 2 children, didn't feel able to do that. The hospital called a special justice, and they went in and took Ms. Burton out of her home, brought her into the hospital, and here's the language in an amicus brief. Against her will, any and all medical treatment, restrictions to bed rest, and other interventions, including C-section delivery, that the court, in the words of the court, the unborn child's attending physician deemed necessary to preserve the life and health of Samantha Burton's unborn child. And I will point out that the state of Florida actually has privacy protection in its state statutes. Laura Pemberton. So when I read about that first case, I was shocked, and I did some investigation. And 10 years prior to that, Laura Pemberton, same thing happened. She wanted to have a child, attempt to have a vaginal delivery. She had a previous C-section with a vertical incision that does put her more at risk. She was laboring at home with a midwife, got dehydrated, went into the hospital for some IV hydration, went back home, actually snuck out of the hospital when eyebrows were raised, and the same thing happened to her. Got a court order or authorization from a special justice. They went into her home. She was in active labor, had been laboring for some hours. Tied her legs together, or strapped her legs together in an ambulance and took her into the hospital, where she had a 4th C-section. I've said I can die happy because I'm the first author of this ACOG, American College of Obstetricians and Gynecologists opinion that pregnancy is not an exception to the principle that a decisionally capable patient has a right to refuse treatment. And I'm going to skip these 2. Again, hearkening back on, just because you're pregnant, that doesn't mean we get to do coercive things and invade your bodily integrity and your privacy. And I'm going to end with these. Very recent New England Journal of Medicine article, a preview of the dangerous future of abortion bans. Surveyed Texas obstetricians. In the survey, they found that some Texas hospitals no longer offer treatment for ectopic pregnancies or send pregnant people home with threatened miscarriage, resulting in some patients returning to the hospital with signs of sepsis. Obstetricians are advising patients with fetal diagnoses of anencephaly or bilateral renal agenesis, both life-limiting diagnoses, to continue their pregnancies until term. Multifetal reductions for pregnant patients with higher order multifetal pregnancies, 3 or more fetuses, are not options, nor is fetal reduction available in cases such as monochorionic twins, where failure to reduce the pregnancy would actually result in the death of both of those fetuses. One patient with ruptured membranes prior to fetal viability had to fly out of state to be treated. She said in the survey that her obstetrician had cautioned her, if you labor on the plane, leave the placenta inside of you, you're going to have to deal with a 19-week fetus outside of your body until you land. This is and a maternal fetal medicine specialist who was surveyed said the only abortion that was provided recently in their hospital happened after a patient was admitted to the ICU for a severe cardiac condition. And here's the quote: people have to be on death's door to qualify for maternal exemptions to SBA. And here's one final paper, another very recent paper by Nambiar et al., a more recent research report on experiences in Texas healthcare. Two large systems, both level 4 designated maternal care facilities. Maternal morbidity at 22 weeks gestation nearly doubled with state mandated expected management of miscarriage, in which signs of placental separation are awaited and the placenta is delivered spontaneously. So this is my final slide. We had results in the midterms that weren't anticipated. So now what? And I'm turning things over to Lynn.
Just have to make sure. Hi. Should I just start going?
Yes, please.
Okay.
Thank you.
Thank you so much for having me. It's a real privilege, and it's been such a privilege to be able to work with Professor Mary Faith Marshall and Dr. Lisa Harris. And I'm going to be going over some of the same territory and also having a chance to sort of informally do a little bit of a dialogue. So let me see if I could share my screen. And there we go. Let's see. Is that working?
Looks good.
So I want to start by saying just a couple of things that to round out some of what Professor Marshall was talking about. I just want to make very clear, because when we talk about issues around abortion and beyond abortion, it's very easy to fall into assumptions and stereotypes and other things. I want to explain that there are no criminalized drugs that are good at causing pregnancy loss. In fact, many of the cases that I've worked on involve women who've been arrested for murder, for having experienced miscarriages and stillbirths, some of which Mary Faith mentioned, based on the claim that their use of methamphetamine caused a stillbirth. And to some listening, that's both not only horrifying, but probably deserving of punishment within the framework that we're talking about. The fact is that methamphetamine does not cause stillbirths, nor does it even have a plausible path by which it could cause stillbirths. So prejudice, misinformation, and junk science have been used not only to lock up Chelsea Becker for 16 months, but to actually sentence women like Brenda Pula in Oklahoma to 4 years in jail for manslaughter. And I'll work with the hosts of this. There's an expert amicus brief from leading forensic pathologist trying to inform a court in Oklahoma that it just doesn't cause stillbirths. And the way I explain it and I know humor of any kind on this subject is risky, but really, if methamphetamine worked as an abortifacient, people would be shipping it to Texas and other states where abortion is banned. It just doesn't work. None of the criminalized drugs are effective. There are safe medications for ending, safe and effective medications that did not exist before 1973, when 1 million women still had abortions every year despite criminalization. And those medications, misoprostol and mifepristone, are the ones that are and can end a pregnancy safely, but not methamphetamine or any of the criminalized drugs. So I've been tasked with explaining Dobbs v. Jackson Women's Health Organization. This is the Supreme Court decision that addressed a Mississippi law that banned abortion after 15 weeks. Once that question was accepted by the Supreme Court, Mississippi switched its argument and said, no, really what we want you to decide is not whether a ban on abortions after 15 weeks is constitutional. We want you to overturn Roe v. Wade. And as you know, the Supreme Court obliged. So it did several things. It overturned Roe v. Wade. And in doing so, it instructed the lower courts when cases come before it questioning laws that regulate or eliminate abortion, to apply what's called the rational relationship test. That is the lowest level of review, and it replaced what Roe had put into place by recognizing that the right to choose abortion was a fundamental right. States that regulated abortion or limited it had to show that their restrictions served a compelling state interest, and that the law they used to do that actually was narrowly tailored to accomplish the end they claimed, the interest they claimed they had, and that it actually really did accomplish. It would further the state's compelling interest. Under the rational relationship test, the lower courts are instructed to essentially uphold any law that serves, has some connection, rational, doesn't have to actually have a relationship, doesn't actually have to accomplish what it says it does, to just a legitimate state interest, of which there are many. And as I'll get to, most importantly for the purposes of this conversation, the claim of protecting unborn lives. And the decision says that what it's doing is returning the issue of abortion to state legislative bodies. One of the purposes of living in the United States of America and the Constitution we have is that we don't have just a pure democracy, we have a constitutional democracy. And the purpose of that is to ensure that certain rights that are recognized as fundamental in the US constitutional rights, some of those overlap with international human rights, that we don't let people vote on those. We don't let a majority of people decide that it's okay to discriminate against somebody because of their race or their religion or their ability. So there are absolute and important circumstances in which we do not delegate to in state elections the rights of people, including their right to what they do in their religious beliefs, and what they do privately in their homes, at least according to some remaining members of the Supreme Court. I've heard a wonderful lecture last night by Professor Kiara Bridges, who pointed out the conflict at this particular moment in Supreme Court history, and that is if you turn the issues of fundamental rights over to state legislative bodies, wouldn't it be appropriate to also acknowledge that those state legislative bodies are limiting the rights of certain groups of people to vote and blocking access to the systems of government and election to many more groups of people, and using various forms of intimidation, including increasing deregulation of guns, so that people can be intimidated as they were during Reconstruction. What the decision in Dobbs doesn't do is evaluate or address the consequences of its decision to the health and lives and the constitutional status of the people who get pregnant, of women. Let's see if I did this right. I'm not sure. Let's see. Okay. What Dobbs, just back to what a rational relationship law is, laws regulating abortion must be sustained if there's a rational basis on which the legislature could have thought that it would serve a legitimate state interest. Could have thought, doesn't have to. And in fact, there's more and more research that states that have laws outlawing abortion or permitting arrests of people in relationship to their pregnancies actually have worse health generally and fetal health outcome in both situations. One of the legitimate grounds is respect and preservation of prenatal life. In other words, consistent with the dissent's stark warning, states in the guise of respecting and protecting prenatal life now have the tools to unlock, I would argue, virtually every form of gender discrimination imaginable. What the majority did was they did say, and I think I might have lost that slide, they said what the dissent points out are various concerns about the health and lives of pregnant women. It's basically one sentence, followed by, however, they do not address the life or value of, here it is, laws, no, I lost it, okay. Laws regulating, however, the dissent does not bother to address the value of potential life. Well, so they've assigned one sentence saying the dissent says that this has consequences to women's life and health, but we're going to ignore that because they don't acknowledge enough the value of potential life. And I would say not only is it tragic, inappropriate, and deeply disturbing that the majority never does actually address what the consequences of their decision will be for the people who get pregnant. It's also not true that the dissent did not address the value of potential life. What the dissent said, and relying on Roe v. Wade and Casey, is that states, in fact, may value potential life. And I think that's completely consistent with the experience of anybody who's been pregnant, anybody who's been around pregnant people, that there is a great deal of respect. How that is carried out, to what extent it's limited, does vary. But what Casey said and what the dissent says and what we said in our amicus brief is, yes, there are many ways in which we can value potential life, but one way that is not acceptable is to do that by denying the constitutional personhood of the people who get pregnant. And what we'll talk about what I mean by that. But in other words, in Casey, the decision that came after Roe, that restated that there's a fundamental right, that exercised the principle of stare decisis and maintained the law, had struck down one Pennsylvania provision, and that was the husband notification provision. It said states can't delegate their decision-making authority about the outcome of pregnancies to husbands. And if they did that, well, then husbands might have the right to be informed if their wives or the women they impregnated used drugs, smoked cigarettes, drank alcohol. Well, as a result of Dobbs being overturned, that part of the Casey decision is overturned. States are now free to pass laws that empower men to control pregnant women. And if you think that's far-fetched, I hope you will go to Pregnancy Justice's website. There's a report called Harming Fathers, and it discusses cases from at least 16 states, including blue states, northern states, in which brand new fathers who were found to be guilty of civil child neglect. Why? Because the court asserted that he did not control the woman he impregnated and force her to get drug treatment while she was pregnant. Now, these cases reinforce mythology about the impact of drug use during pregnancy. They also are used to deny not only the parental rights to pregnant women, some of whom have occasionally used marijuana to deal with morning sickness, to the right to their children, but now they're saying that fathers can lose their rights to parent and can do so because they have not taken literal physical control of the women who they impregnated. So what the dissent says is whatever the exact scope of the coming laws, one result of today's decision is certain: the curtailment of women's rights and their status as free and equal citizens. Because of some of the questions I know have been raised beforehand, I want to talk a little bit about what that broad denial of equality and rights can look like. These cases have been referenced a little bit. I want to go into a little more detail because they're the ones that actually shaped my work and my understanding of what happens when we think about issues only in terms of abortion. Because whatever one may feel about abortion and that it is wrong as a matter of ethics, law, whatever facts you believe, the mechanisms by which states are allowed to control pregnancy, control abortion, are also used, are being used, will be used to impact the people who do not want to have abortions. And among these are Angela Carter, who as a young woman was diagnosed with a rare form of bone cancer, was told she was terminally ill, told she was going to die. She survived that definition, went through multiple treatments, chemotherapies, and surgeries. She's on the left. She had an entire leg and half her pelvis removed. She's with her very brave mom. They let me use this picture, who actually lost her legs in a completely unrelated tractor lawnmower accident. But Angela got pregnant and as a disabled person faced discrimination and difficulty getting care. She finally found OBGYN care at George Washington University Hospital and made clear to doctors throughout that she didn't want the pregnancy to undermine her health and her chances of survival in life, because that's what she'd been fighting most for her whole life. There was a point in her pregnancy where they listened to her. They discovered she'd had a recurrence of cancer. She was 27 years old and 25 to 26 weeks pregnant. And she and her parents and her attending physicians all agreed that what they should do is keep her alive. And that might involve chemotherapy. It might involve radiation, even with its risks to the fetus. It was clear that's what she and everybody who knew her wanted. A hospital neonatologist heard about the situation, decided that she could save every 25-week fetus, ran to the hospital lawyers and said, we should cut her open right now and give that fetus a chance for life. A lawyer was appointed for Angela. A lawyer was appointed for the fetus. And that lawyer had much more experience in reproductive rights litigation and persuaded the court that it had an obligation to give the fetus an opportunity to live, even though it had been made clear to the judge that the surgery itself could kill Angela Carter, could deprive her of her life. When she was told that it had been ordered and it not considered appropriate by her own physicians, she was intubated. She'd been in an intensive care unit. She's taken out of that unit and she's mouthing the words, I don't want it done. I don't want it done. They do the surgery. The fetus, in fact, is so far from viability, a concept that is individual to each pregnancy. In her case is a great example. Because the tumor had been in her lungs, the fetus had been deprived of oxygen for a very long time. And it was born alive, but had no chance of survival, sustained survival. It lived for 2 hours and died. And Angela Carter died 2 days later with a cesarean listed as a contributing factor. There had been an emergency appeal fighting over a telephone, one telephone, to 3 members of the District of Columbia's highest court. And they upheld the order and then afterwards wrote that their condolences were extended to the mother and child. Eventually, we appealed that decision. We obtained the first decision from any court saying that this is what it said. We hold in virtually all cases, what is to be decided is by the pregnant patient on behalf of herself and her fetus. They did use the word virtually all, which has been language that has been used to justify other cesareans after this case. They don't quite foreclose the possibility of cesarean, but what we know from the decision is What it does not leave open, whatever that virtually all possible exception exists, it is not because the woman is believed to be terminally ill. It is not because the fetus is determined or believed to be viable without, in fact, when it even isn't even viable. And it occurs even when the person themselves can't communicate, if that's the case, but must be decided by somebody acting, knowing what their decisions would have been. The interesting thing, and the thing that gives me the insight that I have about the Dobbs decision, is the dissenting opinion in the Angela Carter case. Judge Belson had been one of the 3 judges that allowed the procedure to go forward. Believes, in his opinion, that fetuses, he used somewhat different language because it was in the late 80s, early 90s, but basically he argued that the unborn have rights. And he did something that no other judge I know of did, and none of the majority in Dobbs did. He bothered to answer the question, okay, if we allow recognition of rights for potential fetuses, what will that mean for the people who are pregnant? And his answer was that the expectant mother has placed herself in a special class of persons. He also describes it as women who carry a child to viability. Now with Dobbs and everything else, it's from the moment of fertilization, is a member, in fact, of a unique category of persons. In fact, in the Dobbs decision, the majority over and over and over again claims that other fundamental rights, and the right to marriage for all people, including those who are gay, the right to I'll stick with that one, the right to marriage, the right to contraception. Don't worry, those are not at risk because abortion is unique. Of course, Justice Thomas says we should overturn all of those as well, but abortion is unique in that it ends a life. Well, if the abortion is unique, then the people who carry them are unique. And according to Justice Belson, you may therefore treat this separate class of persons in a way that denies them every fundamental right we recognize, including, as in Angela's case, her right to life.
Lynn, sorry to interrupt, but we should leave at least a few minutes for discussion. So.
Oh, okay. Let me then just move on, and I will conclude by talking about the fact that many of the fears about what will happen in the future, including arrests of pregnant women, denial, being taken into custody through law enforcement and child welfare, are very much likely to come true. Our research shows that those things are already happening. And in fact, what we know is that Justice Thomas, during oral argument, specifically raised the question of not abortion, but the extent to which states would be allowed to criminalize pregnant women, particularly those who are perceived to be neglecting their unborn children through drug use or anything else. I know I may be accused of interpreting the decision, but the people who should not are those who are providing healthcare. If you are in a state where you have where the woman's life and health are recognized, by all means ensure the woman's life or health. These are ethical obligations, and you should assume that your colleagues and many, many lawyers will defend the decision to save the life of pregnant women, respect them, and give them dignity. Thank you.
Thank you. Thank you, both of you. So just a few minutes left, but let me just ask a quick clarifying question to start, which is, Dr. Marshall, since we couldn't quite hear your, we couldn't quite get your video at the beginning. We're wondering if you could just, a couple of questioners were asking if you could give us the citation for that BBC video, and just real quickly, what was the judge saying at the beginning? You're muted.
Thanks. Yeah, he was the Ninth Circuit prosecutor. They call it the solicitor in South Carolina. So it wasn't a judge, Charles Condon. What he was saying was that and I'm quoting him here, this is about the life of the unborn. He says a pregnant woman has a right to have a baby. She has a right not to have a baby, but she doesn't have a right to have a cocaine affected baby, which is the drug that they were targeting. And that's when we intervene. And then that's when I was able to get the video up. So it segued right into that arrest. So great
Thank
question.
you. Thank you. Another question about the point you were making about the history at the beginning of your slides about the link between the pro-life movement and the beginnings of the pro-life movement and the eugenics movement. One of the questioners says, essentially that there may have been a connection, but it's not necessarily true that all people in the pro-life movement would endorse those views. And I wonder if you can just speak to that real quickly.
Yeah, I absolutely agree with that. And I thought that I had said that some, but not all. But, I do think that it segues with the fears that you see, about the great replacement. I mean, those things are kind of married in a way. But yes, I agree with the person who submitted that question. That's certainly not all, and I would say probably not a majority of those who are in the anti-abortion movement are there for because of a racist ideology.
Thank you. Ms. Paltrow, maybe you can take this next one. The one questioner wants to know, what are some of the most effective reproductive rights organizations that we should be watching and working to support? It's often the case in ethics grand rounds that we get a question about what can we all do about the issues. So
That's an interesting question. There are many organizations that are working hard, and I will say Pregnancy Justice, the one that I run, I'm particularly proud of because it works across issues and has for a long time defended people criminally prosecuted for having abortions, attempting to have abortions, and for giving birth. Most of our cases involve people who've given birth to healthy babies, but did something somebody believes was risky. I guess what I don't want to do a big endorsement of other organizations, local abortion funds, absolutely. But I think what's really the issue is if you are working in whatever institution you're working in, it is to get those groups to address the harms and implications of this decision. What we were just hearing about, nobody, apparently white people in particular, are unbelievably hurt to ever be accused of racism. But to not be one individually doesn't mean that the policies that are being put into place don't have extremely racially disproportionate impact. So I encourage people to link these issues to any democracy work they're doing, to their union, to their medical school, to their university, having all of those institutions say, wait a minute, we cannot ignore that the impact of laws, if every law that is passed in the guise of protecting unborn life is allowed, then we are absolutely committing to a second-class status for the people who get pregnant.
thank you. I'm really sorry to say we're out of time. I mean, I wish we had more time for conversation because there are a lot of issues to get discussed here. And I do really, really appreciate you both taking time out of your busy schedules to be with us. I think these are really interesting issues. Let me just say to our audience as we are wrapping up that there are many resources on these issues. The center can try to gather some of them together and post them on the website, linked to the event page for this event. There was, for example, another really interesting webinar at the Hastings Center just this morning. And I also want to remind you of our upcoming events that you can see here on the slide. December Grand Rounds, Dr. Lisa Eckenweiler is going to talk to us on an eco-structural approach to health ethics. And in our Unpacking Bedside Bioethics, our clinical ethics series in February, Dr. Shapiro and Dr. Pope will be talking about consent. Beyond consenting the patient. So we hope to see everybody at those events. And again, my deep gratitude to Dr. Marshall and to Ms. Paltrow for your joining us for today and for all the work that you're doing on these important issues. Thanks, everybody.